what is curious is that the British introduced this law. The British scrapped this law in 2010. And even at the time that the law was introduced, it was considered to be non-cognizable. The fact that it became a cognizable as well as a bailable offence, a non-bailable offence, happened much after independence. It happened, I'm given to understand, in 1974. So while the British have got rid of this law, we have, if any, across governments, only made attempts to try and strengthen the provisions of this law, and perhaps because of that, the propensity of it being misused.
So, Zaka, this is a clear case where the legislature has failed the people, or the parliament has failed the people. When the constitution was drafted, or rather when we became independent, there was firstly, no reason for this to continue in the present form. I'm not saying sedition should not be there, but in the present form, there was no reason for it to continue. And what should have happened, that they should have, in the beginning only, if they wanted to keep this law, made amendment to it so as to bring it in conformity with what Kedarnath Singh did in 1962. But interestingly, Raka, in 1955, the parliament made an amendment to this section. And for transportation of life or any shorter term, they made it imprisonment for life only. So that shorter term was removed completely. Now that was a little surprising, because by the time we had got independence and Parliament actually applied its mind to this law, at that stage also, to reduce any shorter term and make it only imprisonment for life as a punishment was, according to me, completely without application of mind. Because Parliament in its wisdom should have then looked at the law and said that, because here it says whoever by words or by signs says something which brings disaffection towards the government. So that that was really speaking not required after independence, because pre-independence the Britishers were using this law against the freedom fighters mainly, and that is why its repeal or its amendment was very necessary.
In fact,
now after Kedarnath Singh, this law really was read down. Read down to mean that it has to incite violence. I mean, what you do or what you say is not material. You have to ultimately do or say something to lead to violence. Now, when that judgment came, ideally, the Parliament should have amended the law immediately to bring the law in conformity with what the Constitution and judgment did, by saying that it is not only saying something, but it has to say something to lead to violence.
Active incitement.
So that did not happen. That's where the Parliament failed again, the people of this country.
Okay. No, what is also interesting, Vikas Singh, with your permission, what is also interesting is, off late, over the last few years, what we have seen is, and again, I don't want to make this one party specific issue, but look at the latest case that happened, where a political couple who basically just said that they are politically opposed, obviously, to the Chief Minister of Maharashtra. They said they want to go outside his house and recite Hanuman Chalisa. Now, you can charge them for, inciting hatred or causing nuisance, disturbance to public order. All of that is fine. But they were charged with sedition. And that's the question, Aishwarya Mahadev, that it had become, this was clear that this is now becoming an instrument or a tool for settling political scores.
Just let me complete. I have to leave. I'll just complete and leave.
Okay, all right, Vikas Singh.
So I'll complete in 1 minute and then leave. So what happened thereafter, the law was read down by the Supreme Court, but unfortunately the law is to be handled at the level of an inspector or a sub-inspector, and every sub-inspector, while, taking up his position, does not read Kedarnath Singh. He reads what is written in the IPC. And recently, of course, not only because of the sub-inspector, but also because of the state action, like I did the Dua matter, you all will remember. So he was charged for sedition for having said something in a YouTube channel, when clearly there was nothing in what he said to be seditious, and there was nothing to incite violence.
Okay.
So Supreme Court quashed it. But problem that was happening was that every person had to go to court to get a quashing because of this infirmity in the law as it stood, when it should have been amended in line with what the Supreme Court had said. And that is why now the time has come, and I think the Supreme Court has done the right thing, that if the government itself has expressed its desire to amend the law, they have said that it should not be implemented till the amendment actually happens. So in this rethink now, probably they may scrap the law.
Okay.
or they may amend it, and if they amend it, they will have to bring it in conformity with what Kedarnath Singh
Singh has said. Okay.
So really speaking, it will be a huge relief to the common man, and no police officer thereafter, on a plain reading of the section, will be able to invoke this
All right. Okay.
section.
Let me ask aishwarya the political question. When you invoke this against political opponents, I gave the example of the Rana couple in Mumbai, but even in Jharkhand, I'm given to understand a few months ago, basis a complaint by a Congress leader, 3 people were charged with sedition by the Jharkhand police. Was sedition being used as a tool to settle political scores? And is that perhaps why the Supreme Court had also had to step in this matter?
Good evening, Zaka. I think first and foremost, any law that is as draconian that clamps down so arbitrarily on the rights of people to even express themselves on this arbitrary term of saying arising a dissatisfaction against a government is something that did not have place. And of course, this is welcomed. And you know, Zaka, in terms of looking at the propensity of the number of cases over the past 10 cases or past 10 years, over 96% of all sedition cases have come post 2014. You've seen around 22 cases of sedition after the Hathras incident, 20 cases after Pulwama, and you know, some 22 to 25 after anti-CAA. And you realize, and I have to admit, yes, that there are political ramifications when a state, irrespective of who's in power, uses this sort of arbitrary law to clamp down on freedom of speech. And that is something that the Congress also does not accept, as we've said in our 2019 manifesto, saying if we come to power, we're going to read down the law and obviously change it and remove sedition in the strict context that it is. But over the years, you realize, and you know, Zaka, you talk about these high profile cases. Let's not talk about them. When civil society rises up against a government, when they don't have as much agency, as much sort of contact, or as much sort of power as a lot of political opponents do, and when they have charges like this, Disha Ravi, for example, right, that young environmentalist who had sedition cases slapped against her, you realize that it extremely regressive and tramples down on the civil liberties of people. And going forward, let's just hope, one, that arising or affecting dissatisfaction against any government legitimately that can harm the integrity of the nation is bad, but speaking truth to power is not something that should be clamped down as strongly or clamped down at all. Let's hope that the Supreme Court does move on from just this, keeping it in abeyance, to asking for a relook into the law completely, and the government also agrees, because today if you look at the the center's response, Zaka, they have not been too willing because they want status quo to remain, and that is the fact that has come out, Zaka.
No, anyway, the center's affidavit clearly says that there is a need for a relook at this law. Yes, there is a case for the law to continue on the statutory books, maybe not in the current form, but with modifications. But I want to